First, on behalf of everyone here at the firm, I want to thank you for trusting us with your personal injury case. Each and every client is important to me, and I want to make sure you reach out to me personally at any time to speak about any issues or problems you're having. I realize that dealing with an accident, be it an auto accident, slip and fall, or any other type of incident in which you're injured, can be both frustrating and confusing. I want to take a couple minutes of your time to talk to you not only about what to expect in a personal injury case, but also some of the things you need to do and not to do going forward with your case. Don't talk with anyone about your case. Of course, you can speak with anyone in our office and your medical providers, but you don't want to be creating additional witnesses for the insurance company to use against you later on. Do not speak with anyone from the insurance company unless my office arranges for a statement or interview. Generally, statements will be taken in our office. Social media. Don't delete any of your social media accounts that you currently have. The courts have recently ruled that deleting your social media accounts can be destruction of evidence, and this can hurt your case. While you shouldn't delete any Facebook, Twitter, Instagram, MySpace, or other social media accounts, you should refrain from using them during your case. I realize that this is difficult for a lot of clients, but everything you post on social media can be obtained by the insurance company, whether it's marked private or not. You don't want to have to explain why you look pain-free in a picture while on vacation with your family during a deposition or statement. Your close friends and family will obviously know what you're going through, and we understand you speaking with them about your medical treatment and the pain you are going through, but avoid speaking with friends and coworkers about the details of your case. Your doctors and medical providers. Insurance companies constantly argue that if you're not treating, you're not hurt. Make sure you make all of your appointments and seek medical treatment when you need it. This is not the time to be a hero and suffer in pain. Always tell them of your complaints. If you see any additional doctors or referred for any type of procedure or therapy, notify my office immediately before you see them. It's important that we know who you are seeing and for what. If you do what's best for your body, it will be what's best for your case. But we want to counsel you on how it will affect your case and the amount of money you ultimately receive. It's important to talk with us about whether the bills are still being paid by your auto insurance carrier through PIP coverage, through your own health insurance, or if you have it on credit against your future settlement called a letter of protection. Pictures. Provide my office with any pictures you have of the accident scene, damage to your vehicle, or of your injuries. Take additional pictures of any visible injuries you have, including bruises, cuts, scrapes, and make sure to take updated pictures as they heal or don't heal. A picture is truly worth 1,000 words, and it can be worth thousands of dollars improving your damages. If you have to use any medical aids, take pictures using those as well. One of the reasons to advise us of any medical procedures is that we may want to take pictures or video to show what you're having to go through. Keep your contact information up to date with our office. Notify us immediately if you change your address or phone number. It's imperative that we are able to get in touch with you on short notice about developments in your case. Witnesses. Keep a list not only of your medical providers, but anyone else you feel can fairly and persuasively explain your pain, physical restrictions, wage loss, loss of earning capacity, and how your day-to-day activities have changed since the accident. Make sure to get both addresses and phone numbers for any potential witnesses. Keep a journal. You don't need to write something every day, but it will be helpful to look back at your notes when having to testify in a deposition or to help explain what you have gone through because of the accident. The more detailed, the better. There's a big difference between saying I can't do yard work anymore and stating that on May 30th I tried to mow the lawn, but I had to stop after 10 minutes and ask for help. Collect any documents and physical evidence you feel will help us prove your claim, and call us to discuss whether the evidence will be helpful. Medical reports, both past and present, prescriptions, wage and salary statements, and income tax returns are all examples of documents that will help us prove your case. Trophies, awards, trade school diplomas, letters of recommendation, health club memberships, pictures, and other evidence of your active lifestyle prior to the accident may help us show the effect of the injuries on your life. I want to make sure that we are available to speak with you about your case and answer any questions and keep you informed about what is going on. We will probably not contact you unless we have something definite to report, especially in the early stages of your medical treatment. But please feel free to call or write us with any questions you have. If someone in our office is not available to speak with you when you call, please make an appointment to either come to the office and speak with us in person or set a specific time to speak with us over the phone. We want to make sure we have both the time to speak with you about your case and the answers to the questions that you have. So please let whoever is setting the appointment know what you're calling about. Please don't show up without an appointment, as often our schedules don't allow us to meet with you, and I want to respect your time. If your calls or correspondence are not answered timely, call me, Shaun Plymale, directly, and I will make sure it gets taken care of. Now I will give you a brief overview of how a personal injury case works. Recovering a PI case depends on three things: liability, coverage, and damages. We cannot recover money for you without all three. Let's talk about them individually. Liability, simply stated, is who's at fault for the accident. Oftentimes, liability is not clear-cut. Arguments can be made that each party shared in the fault, and ultimately a jury is given the task of assigning a percentage of fault to each party. Every case is different and unique, and establishing liability is much different in a slip and fall case than it is in a rear-end collision. Make no mistake, it is our burden to prove the other side is liable, and most of the initial investigation done by our office will revolve around proving liability. It can be helpful to take some time while your accident is fresh in your mind to write down what happened so that later in the case you don't forget important details in proving liability. The insurance companies rarely admit liability, even in cases where liability appears to be clear. A rear-end collision, for example, they will argue that you stopped short and therefore share in the responsibility. Coverage. Coverage is the ability to pay. Most people responsible for causing injuries are not independently wealthy, so we look to any policies of insurance that they have to cover the loss. The amount of coverage is a huge factor in what we are able to recover for you. If someone has no insurance or too little insurance, we can look to your own policy to see if you have uninsured or underinsured motorists on your own policy. With over a third of the drivers in Florida having no insurance or the minimum amount required by law, coverage is essential for protecting you and your family. Finally, damages. Damages are the total amount of the money required under the law to compensate you for your injuries. What your case is worth. Proving damages is the most difficult and time-consuming part of the majority of personal injury claims. Damages are made up of economic and non-economic damages. Economic damages include past and future medical bills, past and future wages, and any outstanding expenses you have or will expect to have due to the accident. Non-economic damages include pain and suffering, loss of enjoyment of life, inconvenience, both past and future. Proving damages takes cooperation between you and our office to make sure we use everything we can to prove how your life has been affected. Obviously, there is a lot more to the process than what I have touched on in this video, but I wanted to make sure that you understood the basics and some of the do's and don'ts now that you have a case. I understand that your life doesn't stop because you have a case, and your injuries have done anything but make life easier. But make sure to follow your doctor's orders and keep up with your treatment. Don't hesitate to contact the office with any questions you have. Your case is very important to me, and while I can't guarantee a certain result, I want to make sure that you have the peace of mind that your matter is being given our attention. The majority of our clients are referrals from past and current clients, and I want you to feel, both during and after your case, that we're here for you to help with whatever legal advice you need. We handle all types of legal issues and encourage you to call us with any legal problem or question, from personal injury to family law, real estate, criminal, wills, or anything else that comes up at any time, now or in the future. I look forward to working with you to resolve your case. Please remember to keep treating, and that we are here to make sure you understand what is happening in your case from beginning to end. Thank you very much.